There we go. Krista, are you ready to go? Okay. I guess I'm the first part of this meeting today. Thank you all so much for joining us. And I wanted to talk about kind of timeline, next steps, some feedback we've received, which has been shared with you via email. So I received a couple questions about meeting schedule. We have this meeting today, obviously, and then another meeting on November 13th. And that ties in a little bit to the full law commission meetings. We have one this Friday, and then another one in the first week of December. The commission right now has 2 work groups prepping stuff, bills for 2025. You all and the LLC Act. And so there will be a more substantial conversation and potentially a vote on those 2 concepts at the December meeting, so that we can get that information to the legislature in a timely manner. And for pre-session filing, for those folks of you who don't track the legislature like it's the World Series, pre-session filing is December 13th, and if we want to do a committee bill, it would go in, be voted on during legislative days in December 10th to the 12th. The other thing I wanted to flag for folks, and I've emailed you all, was this question on the feedback that we received from a handful of folks around the default judgment conversation, which I really appreciate the deep level of interest and engagement on this. Thank you everyone who filled out the survey. Thank you very much. We also reached out to, with the help of Lindsay and the folks at OJD, to some circuit court judges and shared the survey with them as well. And heard back that there was some confusion on the process and how it would work. In addition, we've heard back from a couple commissioners, full commissioners, current and former, with some confusion around the use of the abusive discretion standard, and a very strong feedback that using that standard would be difficult to get it through the full commission. Finally, we met with Senator Przanski during end of last week to talk about the commission and bill introductions in general and what the projects we're working on. And the feedback we got from Senator Przanski as well was a significant lack of discomfort with the abusive discretion standard. So I really want to thank Justice Kidd and Judge Britton for talking to us earlier this week about this. Oh, I'm sorry, I have 2 more people in the waiting room, I think. Sorry, I lost my train of thought there for a moment. I want to thank Judge Britton and Justice Kidd for talking about this earlier this week. And I also want to thank Jessica in LC's office for rewriting sections 18B and section 19 and working draft number 4. I do want to pass that on and let you all know that that was the feedback we had received. And I'm happy to answer any questions with the caveat that, as you all know, this is not my practice area, so I might need to grab onto lifelines as they come up. Hi, Judge Cross.
Hello. I understand that the abusive discretion is not going to fly, apparently. So I tell you, I would suggest that we not make any amendments at all to the current status of the law. I'd much rather live with the City of Eugene v. Morrison case, which does not answer the question. I think originally this case, when it was brought up, had been posited to say that it was appealable, the ruling on it, or denial of a motion for relief from default judgment. But the last footnote of the case, footnote 7, makes it clear that the court's leaving that for another day. which is probably correctly, would be correctly interpreted as an invitation to raise the issue, that they're interested in the issue. But it doesn't answer that question. And so I would much rather just not amend anything with regard to default judgments and live under the city of Eugene B. Morrison. Happy to do so.
I'd like to address that. I think that the problem, this was certainly something we thought about and whether we could do this. And the problem is that we are revising these statutes that are listed in that case and in this draft bill, and we think it would be pretty much impossible to extricate the default judgment provisions from what we're doing in general in this bill without changing the text of the laws. And that, of course, if we're changing the text of the laws, is likely changing the meaning of them, or potentially. And we didn't see a way to not do sort of the general reorganization because we're generally reorganizing everything, how we could possibly extricate this without changing what's currently there. And I see, Amy, did you want to address that any further?
No, I just wanted to flag that Heather and Justice Kidder have their hands raised, and I'll be quiet.
Heather.
My comment is along those lines. As I read the statute or the legislation as written, it currently enumerates everything that is appealable, and it is so if we don't include these motions or the orders on these motions, then it will mean that they're not appealable. So a non-decision here wouldn't put this back into the place where it was at the time of City of Eugene versus Morrison, because by omitting it, it would just become not appealable. And we've decided a standard of review for everything else. So just also a commentary that I don't see why we wouldn't provide that clarity here now when we have the opportunity.
Krista, you're muted.
Sorry, I'm talking to myself. Justice Kidd, would you like to comment?
I will just say, as I understand the current proposal, it is that motions for relief from default would be a reviewable order, an appealable order. And then what if that judge above decided that the lower court made a mistake, it would come back to the lower court. Do I understand that correctly?
Yes.
I think it was not what I originally wanted, right? And if I was king of the world, I would not do it that way, but I think it's a reasonable compromise. So I disagree with the learned Judge Cross, whom I admire in a lot of ways, but I think that it is better to have clarity and uniformity throughout the state than to live in another, a sort of a zone of ambiguity.
So this was actually second on our agenda. So maybe we can just sit with this for a minute here and go to the first item on our agenda for substantive item and then return to this topic. So the first item was conditional pleas, and we've got we've discussed this in the past. I think it was somewhat confusing about what we were looking at, what the options were, and so I appreciate Jimmy Brewer taking the time to write a memo on it, and as I understand it, hopefully I got it right in the agenda. I think we have 3 different options presented as far as how we can deal with the issue. When a defendant wishes to appeal from the local court's decision on a pretrial motion, either there can first be a trial. So motion denied, trial in the local court, and then appeal to the circuit court and for the de novo trial, or avoiding doing the full trial in the local court first and simply either doing a conditional plea in the local court upon the agreement of the parties in the court and then appealing that to the circuit court, which would then result in the circuit court determining it anew, or avoiding the conditional plea process in the local court and simply transferring it to circuit court after the pretrial motion is denied in the local court. So there's sort of various levels of maybe efficiency and or different court involvement. Am I, Jimmy, correctly stating those options?
I think that's correct.
So I would open that for discussion at this point, and we are going to try and move through these things pretty quickly. So I guess discussion or clarifying questions here, Jordan.
Thanks. Just as a clarifying question, Jimmy, on number 3, where the parties agree to transfer it to circuit court, are they agreeing to transfer it to circuit court for review of the denied motion?
They're agreeing to transfer it to circuit court for everything. It never, once it goes to circuit court, it doesn't come back to justice court. And that's because
Right, but
the next thing you want to do if you lose the motion in circuit court is go to the Court of Appeals, and you need a judgment in circuit court to do that.
right, but I guess my question is, I think the language of 3 is unclear as to whether or not they get to relitigate the motion in circuit court.
Yes, they would. I mean,
Okay.
you'd have to. That's
Yeah,
where
I mean,
basically the record on the motion would be generated. And if for when you go to the Court of Appeals, you need to have that step.
Yeah, I agree. I just wasn't sure from the way it was written. So thanks.
Okay, well, anybody have any opinions on this?
Okay, can I weigh in?
Yes.
Yes.
Okay, for violations, I understood from the draft that I reviewed this morning, the current working draft 4, that conditional pleas were reserved for misdemeanors. Is that correct?
That's my understanding.
Right. So if we're talking about violations, if there's a motion in a violation trial, most often the motion's heard as part of the trial. So number 1 would be the preferred option for violations. But if we're just talking about misdemeanors, then all 3 of these, I guess, could be the choice.
I think that's right. And certainly violation trials are much less onerous than misdemeanor trials, just in terms of the time commitment from the court and the parties.
Heather?
Clarifying question. As I understand these proposals, the main distinction is just whether the parties and the court could all agree to just go ahead and transfer it. But nothing would prevent a party from objecting to that and still having a trial. And so it sounds like really what we're talking about here is just whether we want to have that option available at all upon agreement of all of the parties to just like skip the trial part if they know that this is going to be the fundamental issue. And that would require agreement of all the parties. Is that right, Jimmy?
That's exactly right. Obviously, the defendant could never be forced to give up their right to a trial against their will. Prosecutor and the court also need to agree. That's the same way that conditional pleas work in the circuit court. If either party or the court, for whatever reason, thinks that this is just not a good idea in this case, or it's not going to promote efficiency in this case, they can object to it and it just doesn't happen. And the defendant still gets to go from the justice court to the circuit court if that happens. It just means that there's a trial there. And for whatever reason in that case, maybe the state wants a trial, I don't know, but that's how that would happen.
Jordan?
So the one major advantage of number 3 that I see from the defense perspective is that there's no finding of guilt at the municipal court level, which can be a real hang up to some conditional pleas, especially if you're looking at charges which could have consequences to someone's immigration status that trigger on finding of guilt or admission of guilt, which number 3 doesn't require. So I think that might be the cleanest way to do it. From the defense perspective is if we allow that, obviously it has to be agreed on by everybody, but if we allow it, I think that's just cleaner than requiring a plea. And I guess when I say cleaner than requiring a plea, I mean cleaner than requiring a plea that everybody is just fully aware they're going to be relitigating a week later.
Heather?
Makes a lot of sense to me, and I appreciate Jordan bringing up those collateral consequences, like for immigration. It doesn't seem to me that it makes a lot of sense to force folks to go through a trial if the court, the prosecution, and the defendant agree that that the main issue is something that's going to be resolved at circuit court anyway. So I would advocate for allowing this option. And then also, based on what Jordan said, I would advocate for the third option here in particular.
So I think the question is, it sounds like there's some support here for the third option because of potential collateral consequences for the second option, and it essentially has the same result in the end, as far as the circuit court getting the case. Does anyone object to us going forward with the third option? Okay, it sounds like we've got a consensus around that will add the third option on our agenda, which is a transfer to circuit court upon agreement of the parties in the court. All right, great. So let's go back to the default judgments issue. So to summarize, we are the only issue on the table is the standard of review. The first part of the default judgments question, whether a direct appeal could result from a default judgment itself. We have in the proposal that there would not be a direct appeal from a default judgment itself. It would have to be from the decision on a motion to set aside the default judgment. So that motion would initially be heard in the local court. And then the appeal from the decision of the motion to a denial of a set aside would be appealable. And the question would be what the standard of review is. And as discussed, we've received very clear feedback that an abuse of discretion standard is not a viable option at this point for the commission and the legislature. So we've been instructed to let the commission know at our meeting, our full commission meeting on Friday, whether or not we can propose a bill, whether this work group is proposing a bill that does not include an abuse of discretion standard. And so that's what we need to decide. And you know, again, we've tried to think about whether there would be any way to leave the law as is, whatever the law is, and we haven't been able to figure out a way to do that with our restructuring. So I think the question really at this point is just whether we can go ahead and go forward with whether this group supports moving this bill forward without an abuse of discretion standard. And so what would happen then would be only a consideration anew of the question of the motion to set aside the default judgment. That's all that the circuit court would review, is that motion to set aside the default judgment. And then the case would be remanded to the local court to have the actual trial or enter the final judgment after the question of setting aside the default was decided by the circuit court. So that's the very limited issue that we are talking about here. So I think that if there's any further questions people have about that now would be the time to discuss it. But then I think that we pretty much just need to decide if we can recommend this bill without the abuse of discretion standard with and the language that Lindsay proposed. I'm sorry, not Lindsay. Jessica proposed earlier this week and we sent out, which I actually don't have in front of me right away. Amy, do you have that in front of you? Well, we can get back to that, but I think the question is at this point, do people have questions or comments? Melissa?
Thank you. I was just curious what the general reason behind disfavoring the abuse of discretion standard was.
There are a number of concerns, mostly along the lines of the fact that it's not a court of record means that there's no way to review the record to find out if the discretion has been abused. And it would be essentially a legal fiction where the circuit court judge would be required to sort of assume lots of things that because new evidence would be received and it's reviewing it without a record, it really wouldn't be reviewing what the local court had in front of it and the reasoning of the local court. And so it would be a sort of a fiction that would cause a lot of difficulties and I think confusion, and there would be probably a lot of litigation around what it meant. There could be judges being called as witnesses to explain their reasoning. It raises a lot of specters of sort of how do we do this when it's a court not of record?
Appreciate it. Yes, thank you. I appreciate it.
Any other comments or questions?
If I could make just one comment, I don't know if the tenor of the discussion may be that the assumption is that when defendants appeal the denial of a motion for relief from default, that the circuit court is going to, on de novo review, reach a different decision than the local court did. I would anticipate basically the same record as happens on appeal from convictions, which is that the circuit court reaches the same decision that the local court judge did, and that the circuit court will affirm the orders denying relief from default. Obviously, occasionally they will reverse and send it back to the local court for trial, but I would anticipate that in most instances, the circuit court will reach the same decision that the local court judge did.
And I see the comment or question in the chat about whether written findings could cure this problem. And that was also something that was considered, and we didn't think that it could because, again, there would be new evidence being received, and it wouldn't, because it is trial anew, it wouldn't necessarily be the same things that the local court considered. And so again, no judge would actually be allowed to consider the state of the record in the new hearing. It simply wouldn't be allowed for the judge to do that. So that would be an issue. Heather?
I was just pulling up the draft in front of me, and maybe you found the language, but essentially, as I recall reading it earlier today, it proposes making it simply that the matter be considered anew as though it had been originally considered by the circuit court. And I understand that to be the same standard that's being applied for basically anything else that's coming up to the circuit court from in these appeals. And so it seems to me to be, consistent and straightforward. And so I thought the language made a lot of sense.
I do have one other comment. Maybe we should be concerned. When I originally worked with the work group, we thought it was fair that if the defendant had the opportunity to appeal from the denial of relief from default, that the prosecution would have the opportunity to appeal from the grant of a motion for relief from default. It occurred to me later when I was working on something else that if there are, as to justice and municipal courts of record, appeals in those cases would be under ORS Chapter 19 or ORS Chapter 138. And the prosecution would not have the opportunity to appeal from an order granting a motion of relief from default in courts of record. So if we continue to include that provision as to local courts not of record, there will be that difference between the two courts. And certainly as to violations, considering how generally short the trials are, it probably doesn't make sense that the prosecution would take an appeal from an order granting relief from default, risk having it go up the circuit court, have it reverse, and they'll go back to local court for a trial. So we may wish to reconsider whether we allow the prosecution to appeal from judgments granting relief from default.
Does anyone have any comments or clarifying questions on that? Justice Kidd?
So just reframing from sort of the actual question before us is, do we have a bill that we can recommend or can we not? Right? Is whatever disagreement we have about this so big that we need to like hang out for another year or decide that we have nothing to say? Or do we think that the bill is mostly good? And so with that framing, I say that it's mostly good and that we should support it.
And thank you for bringing us back to the main question here. And to be clear, we do have to decide today if we have a bill to go forward. Unfortunately, we are out of time to do anything other than that with this legislative session.
And I had a comment about prosecutorial, but ability to appeal from denial. But I think with Justice Kidd's framing of the question, I think the bill is acceptable to move forward. I am, however, happy to tell stories about defaulting judgments against prosecutors, if anybody cares to listen to them.
I guess the question is there something about what we have in as far as prosecutorial appeals that presents us a significant problem that we really need to address, or can people live with what we've got in there? Jimmy?
I'll just say, I think Jim is right that maybe there's an argument that this shouldn't exist, but I think Jim is also right that it seems very unlikely that prosecutors are going to be using this a lot, and thus it just may not practically matter whether the option exists or not. I think maybe there's going to be some egregious case where a local court is consistently misapplying a standard and the prosecutor then wants to get it up, and maybe that should be available. But I think it's just a really low stakes question.
Okay, does anyone else want to weigh in, or is anyone objecting to the bill as is on that question of prosecutorial appeal?
On that question, no.
So let's return to the other question as far as the standard of review for the set aside determinations. Is anyone objecting to the bill going forward with the standard that Jessica outlined for determination anew of the motion to set aside determination?
That's the conflict I'm having in my mind as we speak. because I really do not like this provision. I grant you it may not be so many cases or be of that kind of greater significance in that light, but I am very troubled by this point, and don't love the way it was decided outside this committee before we had finalized our position here, but that's beside the point now. But I'm struggling with that, and I'm really debating how I'm gonna vote here when you call for a vote. If you call for it.
Yeah, and I don't know that we're necessarily voting. I think we're just working on a question of consensus to move it forward out of this work group and to have a bill. I mean, really, that's the question, because we can't, we're out of time to do any other negotiations on this.
Well, my guess is whatever I think, the group may have the consensus to send it forward. But I didn't get not a lot of people chimed in on my side of the fence there when I brought up my problem, so.
I'm not bothered by your problem at all, Justice Cross. I think you have a valid point. If you're asking for a consensus, I do think you need to take a vote so that you can at least tell the commission how many of the work group members supported the bill as it is currently written. I have other problems with the bill. There are provisions that I've talked about before about where appeals should be sent or notices of appeals have been sent. So I'm not completely happy with the bill as now. There's been significant changes to it since the last working copy, so that a final working copy number 5 would be helpful to make a better decision. So you're asking, if you're asking for a consensus, then I think you need to take a vote, because I don't know that I could support the bill moving forward.
Can you clarify what those concerns are? Because I don't recall receiving any emails from you on feedback. Can you clarify that?
Well, we have talked about it on work groups before, and you have had some people who have sent emails with other concerns about this de novo process that haven't been necessarily fully vetted. And so if that is, if the bill is going to move forward as the work group tried to work through it, and this is the best that it could come up with, then fine. And then move it forward to your commission. But there are provisions with regards to, we got through pretty good part of it about who would do the appellate process or who would do the notice, when the justice court was going to do that. But there's a provision there that there's still a notice to the district attorney, even though we're talking about giving notices to the adverse party, and that hasn't been stricken. Then looking through the ending part of the bill, there are changes that have been made to the laws, but I don't know for sure that they match up to the provisions we're suggesting. It's a complicated bill to read. I think we can all agree on that part. So that's part of my concerns, yes.
Okay, it would be really helpful to know which specific provisions you're talking about so that we can look at those.
Like subsection 10, I believe, subsection 10 talks about giving notice to an adverse party. But it seems redundant to have also giving a notice to the county attorney or the district attorney, and the case brought in the state's name. That seems redundant to me. Maybe there are other ways to express that, but that's one of my concerns. I'd be happy to more fully put them together in an email when I have a chance to do that.
Can I ask a clarifying question, Krista? I'm wondering, this question around our degree of comfort with the bill and consensus. I was understanding it to be whether this particular issue on the agenda is a deal breaker for us or not. And so we're not saying that, like, we're happy with everything in the bill as written. Like, at this moment, we're going to call it after we have this vote, not meet next month. Like, and I know we have limited time to address outstanding concerns, but if I was understanding correctly, the question before us was just whether we're comfortable with the standard of review for this particular issue of appeals for motions for relief from default judgment, not whether we have no outstanding concerns. Is that right? Or am I misunderstanding?
Yeah, thanks for asking that clarifying question. That was the major issue that we were aware of substantial disagreement on, as well as we haven't discussed very thoroughly the municipal court restrictions question, and we do need to move on to that now. So as far, what we need is to know if there's any major issues that are deal breakers for people. If there's a few small tweaks that we need to make after this meeting, we can do that, but we are talking about deal breaker issues for moving this bill forward, because we have to let the commission know if we've got a bill for this session. So, so that's the question now, and also for LC's time, they're now very busy, extremely busy, because this is the high season for getting bills drafted, and they have extremely limited time to do any major revisions on this bill. So we're talking about anything that's very significant to people as far as saying, no, I'm not going to support this bill if we don't do this, and that's going to require significant rewrite of things. Justice Kidd.
Just the one thing that's really significant to me that we have not talked about in this whole group is the undertaking and the FED matter. So I didn't want to make sure we have time to just like even mention that, but that's really important for a big part of our practice.
Yeah. Okay, let's move on to the other things we have to address. And then I think at the end, we really just need to know if there's anything that is, you know, a deal breaker here for people, and we'll talk about that. So the next question on here was whether we need to have any reference to ORCP 71 or deal with that. It's my understanding that from what feedback I've heard in the civil case arena for default judgments, that the statutes currently incorporate ORCP 71 as the standard, unlike the different provision we've got in place for the violations in the civil cases. It seems that there's not really a question that ORCP 71 applies, and we don't need to address that. Is that people's understanding for civil cases?
Yes.
Okay. All right, so moving on then. Does anyone have any other issues on the default judgment question that we need to address? Okay. Now we need to talk about Jim's proposal on changing the municipal court appeal restrictions on appeals for municipal court decisions. And I think we've had some very recent feedback come in that we need to talk about. And Amy, did you want to address that, or do we have the people in the room here that we need?
I think Scott's here. He was earlier.
Okay. Scott, would you like to talk about your concerns with that?
So thank you. I'm Scott Winkles, and I'm a lobbyist for the League of Oregon Cities. I say lobbyist, I am not an attorney. And I apologize because I have a standing conflict with this meeting, and I have left the conversations to our city practitioners in this area to advocate for the position, but I was contacted in regards to this matter. We do have concerns with this moving forward. It would definitely impact our ability to support this bill, a bill coming out of the committee. I think the way we're viewing this is it would limit the utility of municipal courts, and we provide a vital function to this process. I think I'll also point out a couple of practical matters here. The first being that if these motions go to the circuit court, our understanding, or the state courts, our understanding is the state would then provide the public defense for those defendants. We would not. That system is currently in crisis. I do not see that situation changing in the near future. I think that would be a significant hurdle for getting that bill out of the legislature right now. I think it would probably have a fiscal on the state, on the state courts and the public defense system that the legislature is most likely not going to be willing to fund. I also will point out, we would view this as an intrusion on our home rule authority as well, which we protect very dearly. So I think we would encourage the league would encourage this group to not proceed with these changes that have been proposed.
Does anyone have any clarifying questions around that? I think with that in mind, it seems like that's not an issue that we can make that proposed change to the law in this bill at this time. So anybody want to talk about?
If I could.
I would, sorry, Jim, I'd just like to point out that these were things like the issue of who funds public defense on appeals were things that we have discussed in this committee. And I find I don't know, I don't mean to be rude, Scott, I understand conflicts arise, but I find the last minute like raising of these issues somewhat annoying.
I mean, Jordan, sorry to interrupt, but I
was
sort
done.
of raised this issue as well at the last meeting. Sort of I felt a little bit caught flat-footed when I was asked for my opinion, but essentially we're talking about 2 bites at the apple for individuals who get de novo review. And if we're sending it up to the appeals, this is like the 3rd. So what's really the point of municipal or justice courts if, and then when we're talking about public practitioners and the shortage of them right now, that is a very real issue. One I'm not sure that we've had in quite some time in the state of Oregon. And so I think it is an issue we need to think about when we're talking about proposals of this magnitude. And I apologize for my delay in getting substantial feedback to Amy and Krista this morning. But I do think it's something that has existed. The limitation on appeals has existed for quite some time. It's been litigated multiple times as evidenced by Jim's memo. And if you look at the reasoning regarding equal protection in City of Klamath Falls v. Winters, I think that case really summarizes greatly the reasons, and they're still relevant today, of why there is no finding that 221360 as written violates anyone's due or equal protection rights. There are advantages and disadvantages of being a defendant in a municipal court not of record who gets a de novo appeal right. And then there are advantages and disadvantages to individuals who initiate their case at circuit court. And I think those are pretty obvious. You get 2 bites at the apple. If you're a municipal court, you get the unlimited right of review if you go start in circuit court.
Well, just to clarify, the defendant by definition never initiates the case.
But they do have the ability to immediately remove the case to circuit court. That's a right they have.
They do, but having practiced in municipal court for several years, it is not a right that is widely known.
So I think that the bottom line for us today here is that there's substantial disagreement on changing the law in this area. And so this is not something we're going to be able to go forward with in this bill. If people think that this is something that would be worth addressing in the future, that is something to talk to us about. And perhaps that's something that could be further addressed in another session if we're going forward with this bill this session. Heather, did you want to say anything else before we turn off of that subject?
Yes, I did. So I think at a minimum, the current bill needs to maintain the status quo. And I agree with Melissa's characterization of the Winters decision. However, under current law, individuals are able to appeal even without a constitutional issue out of the municipal court to the circuit court. And something that I highlighted previously and then in an email to Krista and Amy this morning is that I understand there to be a provision in the current legislation that would also limit that so that individuals wouldn't even have that de novo review of a municipal offense at circuit court. And so I think that if I'm reading that correctly, that would really be limiting individuals' rights so that they could only have it heard in the municipal court and that there'd be no appeal at all to any court. And then the other thing I wanted to say is that in City of Eugene versus Lincoln, the Court of Appeals said that a defendant can have substantive issues considered by the Court of Appeals, even when the matter originated in a municipal court that is not a court of record, as long as there's also a constitutional issue. And so the way the bill is currently written, I'm concerned that it would be making it only appeals of constitutional issues, not allowing consideration of any other matters by the Court of Appeals. And so that would be superseding City of Eugene versus Lincoln. And so it's just important that if we're leaving things as they are, that we actually are doing that. And I can provide the particular text that is concerning for folks to consider.
So I think that the intent would be to leave the law as it is. And so if what we have here does not do that, if people want to send us language in order that we can do that, that's what the intent would be. Does that make sense to everyone?
And I can send that, I will send that to the entire group so that others can, you know, agree or disagree with how I'm understanding the law. I'm not trying to like introduce like something new to the process, but I genuinely think that the current language might not be capturing everything.
Melissa?
Sorry, Heather, are you saying that you think that how we have the legislation written would get rid of the appeal rights that is under the current 157.010, which would allow appeals de novo unless it was based on a plea of no contest or guilty?
No, my concern is that it would get rid of ORS 221359 for municipal offenses, where that allows an individual convicted of like a city crime, like a Eugene ordinance, to appeal to circuit court.
Okay.
When there's not a constitutional issue.
And 221359 just refers back to 157.010, which says, because 221359 says that municipal court appeals will be taken in the same manner as provided in 157.010.
So can I say, like, can we just have this conversation at a different time since we have such a limited time? Is there any concern about just figuring out the language that we need to leave the law as is? I mean, I understand it's not everybody's first preference, but that's all we can do at this point.
That's fine, Chris. I just want to make sure we're talking about the same thing.
Absolutely.
That's more of
having,
it, the issue.
Having a side conversation after this, I think, is probably the most efficient way since we've got a few other substantive issues we've got to talk about. Is that okay with everyone?
Krista, I am really concerned. To me, this is one of the major issues that justified forming the work group at all. And I am so frustrated that we did not get to this issue until so late on, like almost 5 years into the process. And now we have no time to form a work group to see if there are any other possible solutions. And it's ended up being an all or nothing thing. I could live with drafting the bill to preserve existing law if there was a commitment to the work group to continue working on this issue so that potentially when the bill comes up for hearing in the legislature, perhaps the work group could offer an amendment to it that would soften somewhat the current law. It's just really frustrating to me that this is, to me, extraordinary that we don't allow any appeal by, not any, virtually no appeal from municipal courts. And I would really like to have the opportunity to have a work group explore if there's some way we can soften that. And it just frustrates me that we've run out of time to do that.
what, I totally appreciate what you're saying, and I'm trying to figure out, practically speaking, we have a time limit here, and this is very substantive.
No, I'm fine because of the time going forward and having the bill introduced. What I'm saying is just because the bill is introduced doesn't mean that this work group can't continue meeting and perhaps come to some sort of compromise on this issue and offer that as an amendment when the bill comes up for hearing in the legislature in January, February, March, whenever that happens.
What I'm thinking, just off the top of my head here, is that conversation can certainly continue. The question of whether we can get together an amendment for this session is not certain. But the conversation can certainly start and continue. And with the recognition that this legislative session is not the last legislative session there will ever be. And maybe not everything is going to get decided in this legislative session. Does that sound reasonable to you?
Yes. I mean, if it doesn't happen until 2026, okay. But if we could at least get a commitment from the work group to continue working on the issue.
I think there's no reason that conversation can't continue. The question is who's going to lead it and how, and depending on how much we have to deal with between now and the legislative session, I'm not sure how much we'll be able to get to it this session. So I don't want to make any promises about thoroughly vetting it this session.
Understood.
Okay, but I will commit to trying to facilitate the ongoing, or make note of and facilitate the ongoing conversation. Okay, we have only 5 minutes left, and we have a couple of substantive things we need to address. And I think, first of all, going to the proposal regarding eviction claims and for payment of rent as the undertaking that was sent out yesterday. Does everyone have that language in front of them? And Justice Cade, would you like to just briefly say why this is important?
Yeah, so it's unclear right now whether, so an undertaking is an amount of money that the court can require to be deposited during the time that the appeal is going on. And so it's unclear right now whether the court can ask for payment of rent to the court while this appeal is happening. So some courts believe you can. I actually don't think you can because the statute talks about money that's going to be recoverable through the case. And so what we propose is just a really simple clarifying fix that the judgment can be stayed. And as staying the judgment, the court can require that rent be paid into the court, similar to what happens when something's appealed from circuit court on up.
Heather?
Yeah, we support this proposal with an offer of a friendly amendment, which is that it model what currently exists in the circuit court, which is not discretionary. It's as of right, and that provision can be found in ORS 19335 subsection 2. And so we think that a defendant should be able to do this as of right. And then the other thing was that we thought that there might be some confusion in section 1C of this proposal around what happens to a monthly payment into the court while the appeal is pending. And we understand that in circuit court, and we've seen this in case law, that the practice is that that the plaintiff can make a motion to have those funds dispersed to the plaintiff. And so we wondered whether that would make sense here too as well.
In response to your question, I think that a motion to disperse makes all the sense in the world. I don't think you'd have to have it in the statute, but if clarity aids people who are not lawyers, then I think that's a great idea.
Heather, if I could ask a question, my understanding is that acceptance of rent by a landlord constitutes waiver of grounds to evict a tenant. Are you saying that under existing landlord-tenant law that the legislature has changed that rule?
My understanding, and I'll admit that I'm not one of our primary landlord-tenant practitioners. My understanding is that that wouldn't apply in this context where it's through the court and it's a part of this this FED process. And there are some, I think there might be some context where that's not the case too, but that's not how it plays out for this, I don't think.
I mean, I'm just wondering, do you have any idea how often this happens?
I don't, although I also am unsure that there are a ton of appeals of these matters either.
And I'm gonna have to cut this conversation off. I think that this is, if we've got are we kind of generally in agreement that this is a concept that people would like to pursue and we can figure out the details offline here? Does anyone object to that? And again, this isn't our last meeting, but we're trying to figure out if we've got a bill to go forward today. That's our plain goal here. So we've got a few more things on our agenda that we didn't get to, but I think that they are smaller issues. Is there anything else that, and again, we can work on these offline and come to the full agreement on this, on these smaller issues. Is there anything else that people feel like is a major deal breaker that we have to agree on today? Or I guess there's been a request for a vote on whether this bill is going forward or not. So I think first question, any other issues that are complete deal breakers that we haven't talked about yet today? Okay, and then I guess since there has been a request for a vote, let's go ahead and do that. Is everyone that's in favor of the bill going forward with continued minor modifications as we work out in the next few months? Please raise your hands either physically or with the emoji uses. I'm waiting. There's some people that are off screen. I'm not sure if they are purposefully abstaining or just having trouble getting to their hand raise icons there. So I'm gonna go ahead and move on to who is anyone, I'll let you put your hands down, your emoji hands down. Is anyone opposed to this bill moving forward with, again, ongoing minor changes? Okay, we have one person, Judge Cross, it looks like. And Melissa Franz also opposed to this moving forward. And can you explain, I think I know Judge Cross is because of the default judgment issue. As far as I know, Melissa, what's yours?
So I share Judge Cross's sentiments regarding the default judgment issue. It's definitely not my favorite, although I understand the reasons behind the abuse of discretion issue. And then the reasons that I set forth regarding the limitations on appeals.
And I just like to say the issue on default, yes, that's one, but there's a lot more serious issues which are more than minor adjustments that have been raised here by other folks that I think just take us out of the realm of where this is something small that we can fix going forward in the session.
And what are the issues in particular that you think are major ones that need to?
Well, the ones outlined by Jim Nass, and the one outlined by Bill Golden, and the one outlined with Melissa, and then one out. That's just three off the top of my head. I mean, I don't think those are just minor little things. I think those are rather substantive, and they're clearly not hammered out.
I'm hoping that we can come to consensus on some of the on those issues other than the municipal courts appealability issue, which I think we've suggested is probably larger than we can do, but we can keep trying. Melissa?
I just had a question regarding the discussions you wanted us to take offline. Shall we include for those smaller individuals having those conversations? Did you want to be included on those emails or just the final
Either way works.
discussion? Okay,
Either way works for sure. If you want to start, either way works.
okay, thank you.
In the end, we'll have to have the full group discussion.
Right.
I'm happy to help as necessary in the interim. Okay, well, I think the question is, at this point, there's clearly a large majority that feels that this bill is should move forward this session. So, Amy, do you have any thoughts on procedurally what we should do at this point?
I don't actually. Sorry. We have another meeting in November. And sorry, I'm not sure what you're asking.
Well, I think that the default judgment, it sounds to me like the default judgment issue, we have again, there are two people, it sounds like, that would prefer the different standard of review, which is apparently not going to fly. And is that alone a reason that Judge Cross and Melissa Franz, that you would oppose the bill? Is that alone a reason, or is it the other reasons?
It's the combination of that plus the other rather significant issues raised that I don't see as minor adjustments to the bill. Other folks have outlined a lot of that. I mean, I grant you, I wasn't too focused on the municipal court side of things for much of this, and there's a lot of there seems to be a lot of disagreement, a lot of work that would have to be done to get that ironed out. That this bill, that we're not going to be able to do in the context of this bill, would be my guess. Could be wrong, but I'm not comfortable recommending this to go forward with these questions out there.
The default judgment issue is not alone an issue for me. And I will say there are provisions that Jim has drafted related to limitations on appeals that not all of them are what we're opposed to. It's the changing of the status quos that we're opposed to in terms of appeals regarding constitutional issues. So I'll just leave that.
So to clarify, if there's no change on the status quo on the municipal court's appealability issues, then the default judgment issue alone is not something that you would oppose the bill on.
Yes, that's correct.
Okay. Well, I think that we can take this information to the Law Commission, and that's where we're at this point. You know, we've done a lot of work for many years, and some of us for more years than others. I would be very sorry to see this not go through this term and lose that momentum. So I hope that we can continue to work on the issues that remain. And you know, everyone, I just ask that everyone that has an outstanding issue, please email us so that it's because it's very hard to keep track of all the individual comments today. Please email us all of your outstanding issues and that you feel must be resolved in order for this bill to go forward, and so that we can see what we can do about them in the upcoming couple of months that we have till the session starts. Are there any questions about procedure or what we're doing at this point? Okay, I thank you all very much for your time and effort. And we will see you next month regardless, and we'll give you updates as we have them. Thank you for staying overtime too. I appreciate that. Okay, thank you. Bye-bye.